Welcome to our informational series presented by motenanthelp.org and Missouri Legal Services. We will discuss the different types of legal evictions in Missouri. First, let's discuss rent and possession evictions. This type of eviction occurs when a tenant's rent is past due. If your rent is past due, your landlord can file a lawsuit against you for rent and possession. Your landlord does not have to give you any warning or notice prior to filing a rent and possession lawsuit. Upon receiving the summons, a complaint or petition will be attached detailing the tenant's residence address, the monthly rent amount, that the landlord demanded rent payment from you, that you have not paid the rent, and the amount your landlord claims you owe. If the landlord's claims are validated, they may be granted possession of the property and the owed rent. You may also be required to pay your landlord's attorney's fees if your lease contains an attorney's fees provision. Next, we address unlawful detainer evictions. Typically, this type of eviction is filed if you don't move out after your lease ends, if your landlord gives you a notice of lease termination, demands you move, and you do not move, or when a landlord is stating that a tenant has violated their lease. If the tenant is still in the lease term, the landlord must have demanded the tenant vacate and given notice of the lease termination prior to filing of the lawsuit. Even if you pay rent, in some cases, you may still be sued for unlawful detainer if you do not move out after the termination of the tenancy. If the judge rules in favor of the landlord, the tenant may be ordered to vacate and could be liable for double rent, damages, and court costs. Lastly, let's explore expedited evictions. Under certain circumstances, a landlord may be able to file a lawsuit requesting an expedited eviction. An expedited eviction action moves more quickly than other eviction lawsuits. If the landlord obtains a judgment authorizing eviction, the judge can order that the sheriff carry out the eviction immediately once the judgment becomes final. The grounds for filing an expedited eviction are drug-related criminal activity in or near the tenant's unit, or emergency situations requiring immediate action to prevent physical injury or significant property damage. Before trial, landlords should give the tenant a reasonable opportunity to review all of the landlord's documents or records relevant to the eviction. The tenant cannot be evicted in an expedited eviction action if the tenant can prove the activity did not occur, the tenant did not assist in the activity or know that the activity was occurring, or that the tenant was unable to prevent the activity because of physical or verbal coercion. If the activity was committed by someone other than the tenant, landlords must provide a 5-day notice allowing tenants to take action against the offender. If you believe you may need to defend yourself in an eviction proceeding, you can find other helpful resources online at motenanthelp.org. By being informed, you can better navigate these legal processes and protect your rights. For more detailed information or legal advice, consider consulting an attorney. The information in this video is not legal advice.